Let's bring our friend Will Chamberlain back onto the Annie Fry Show. He's a senior counsel at the Article 3 Project. You can find him on Twitter at Will, not Wilt, Will Chamberlain. Will, welcome back to the show. It's good to have you here.
Good to be with you, Annie.
What do you think so far about the testimony that is coming from Michael Cohen, the convicted perjurer, in the pursuit to get Trump in Manhattan?
I guess I'm not surprised by what I'm seeing on direct. He's been saying the same, basically telling the same story about Trump for a few years now, but trying to go after him. But I think what Jonathan Turley highlighted is the really important point, and why I find of all the people who ever were involved in anything related to Trump and Russia, I actually think Michael Cohen might be the single most despicable person in
Wow.
the entire affair, including all the Democrats. And the reason is he is an attorney who sold out his clients' confidences, right? Right now, he is testifying against his formal legal client in court. Recordings of conversations he had with his client were played because Cohen himself recorded them and leaked them. And as a lawyer, I'm appalled because the one person who has an ethical obligation, and this is drilled into you in law school, you have a serious obligation to your client. If your client tells you they killed someone in the past, you don't get to reveal that confidence. It's unethical for you to do so because that's the attorney-client relationship. They have the ability to trust you so that all clients can trust all their lawyers and people can have due process in the system. And Cohen didn't just breach that confidence. He literally built a career and built a money-making stream off of saying, I am about to reveal all of my former clients' dirt, give me money. He is the most disgusting person in the entire affair.
That's a statement, and really, really hard to disagree with. Will Chamberlain with the Article 3 Project talking to us today about the current situation going on in the Manhattan trial, the non-hush money trial. Michael Cohen takes the stand today. You're talking about that being drilled into? It's an ethical thing. I assume that there's no legal obligation for attorney-client privilege.
Right.
How does anybody, if there's no legal conflict here, but it's a gross unethical behavior, how could anybody in that has to surround themselves with lawyers, like a businessman like Donald Trump or a politician or whatever, how could anybody ever trust anybody for legal advice again?
I mean, the guy has been disbarred, so he can't practice law again. He did get sent to jail for perjury. So like this, I'm confident, that to say that this is an aberration, this is not a normal lawyer who just is behaving horribly unethically. This is just a Michael Cohen thing. But yeah, I mean, you could maybe win a civil suit for malpractice or some sort of like breach of contract type tort against Cohen if you're Donald Trump, if you wanted to. But I mean, the guy's broke anyway, so it's not like that.
Yeah.
That's a big win. I think the real takeaway here, and somebody else made this point, you know, Michael Cohen didn't just breach his confidences to his client. He's repeatedly lied under oath in a number of different forums. He lied under oath in Congress. He lied under oath when he testified on the stand in previous events. He's admitted to doing so. And so as a prosecutor, your job is to seek justice, and you shouldn't be putting people up on the stand that you can't trust for if their testimony will be the only evidence about a key element of the crime, which is true in this case, right? Michael Cohen's going to be the only person testifying to Trump's knowledge about the supposed falsification of the records. If Trump didn't know about it, it's even if everything else is true, it's still not a crime. So the prosecutors themselves did something horribly unethical by putting this unbelievably unethical lawyer on the stand.
We're speaking with the Article 3 Project Senior Counsel, Will Chamberlain. So that's the question. Everybody keeps referring to him as the star witness and then giving a litany of the things that you've just explained to us about his lack of credibility, gross lack of credibility. If he is the star witness, he has to convince, because I think it's very difficult to drill down exactly what the alleged crime is here. What does he have to get the jury to believe in order for them to arrive at a guilty verdict?
He has to get there's two elements of Donald Trump's state of mind that he has to be able to testify to by testifying to conversations that the two of them had, right? He needs to be able to demonstrate that Donald Trump knew about the fact that they were going to falsify business records, and that he knew that there was a campaign finance violation inherent in that, right? Like both of those elements of knowledge are important because this isn't just a misdemeanor, it's a felony. To upgrade it to a felony, the falsification has to be in service of another crime. And that also has an intent requirement. So Donald Trump not only has to be thinking to himself, aha, I'm going to deceive people in these business records, but also I am doing so because I am essentially trying to circumvent campaign finance laws. And they don't, that's a very difficult thing to prove, right? Because you actually have to get testimony that, or some sort of statement to demonstrate what Donald Trump's state of mind was. And the way the prosecution has decided they're going to do that is they're going to put a convicted perjurer on the stand to describe Donald Trump's supposed state of mind.
So, Will Chamberlain, speaking with us right now, you said that they have that the prosecution has to convince the jury of Donald Trump's state of mind, and I would assume that phrase "beyond reasonable doubt" has to be in play here in order to find him guilty. They have to the jury has to be so persuaded beyond any reasonable doubt that Michael Cohen is telling the truth here in order to find Donald Trump guilty of a charge that, as I understand it, they had to go through some legal gymnastics to get it into the court system that they're trying to prosecute this in, because the campaign finance concerns, am I saying this wrong, were actually a federal offense and they passed on the opportunity to prosecute him there?
So the reason they have to get this additional crime and they have to prove the intent for this additional crime is because they needed to make this into a felony. And the reason is because of the statute of limitations. For this particular crime, the statute of limitations is 3 years if it's a misdemeanor and 6 years if it's a felony. For it to be a felony, it has to be in service of this other crime. So because this was brought last year and indicted last year, the statute of limitations had run on the misdemeanor charge. So it was felony or nothing. So that meant they had to go through this whole convoluted process and convoluted theory to get to a place where they could even indict the former president.
Man, I'm not in any way, shape, or form a legal mind, which is why we rely on you, Will, to come on here and give us this insight. But it's even harder to do it when the legal theory doesn't even make sense when you explain it because of the gymnastics they're having to go through. I want to go back to something that you said a little bit earlier here, and you kind of said it in passing, but I think it's such an important part of the Michael Cohen part of this equation. You mentioned the fact that he's broke.
Yeah.
What is the consistent thread here in all of the lying that he's done in front of Congress and courtrooms and everything that Michael Cohen has done? It seems as though he has been invested in the Michael Cohen brand, and any publicity is good publicity, that he wants to translate, I guess, in a TV show, The Fixer or whatever this is. We're going to play that later on in the show. It's outrageous. It seems as though the outcome for Michael Cohen is that people want to see more Michael Cohen, and that everything he's doing right now might translate in people investing more of their time into consuming Michael Cohen in whatever capacity they can. And if he's broke, there's motive there in my mind to continue on doing these outrageous things, because in the end, even though you and I might not understand it, Michael Cohen still sees a benefit.
I also think I think the big one is this sort of irrational revenge motive that Cohen has. I mean, remember, Cohen worked for President Trump, and I think there's reports that he thought he was going to go to the White House when President Trump, got in 2016, and that just didn't happen. I think President Trump knew well that Michael Cohen wasn't somebody you could trust, and that he wasn't going to bring along in a serious position. And I think that stung Cohen. And then I think also Cohen felt like Trump should have pardoned him or something. And so I see this as sort of a long-running revenge fantasy, but that in itself is an indictment of Cohen's credibility. If you're on the stand testifying to all these things and you have this underlying implicit motive that you hate the guy and you want to see him in jail, well, that colors. Shouldn't we doubt whether what you're saying is true? I mean, I even saw a liberal legal analyst, Eli Honig, on CNN make this exact same point about Stormy Daniels, where he's like, the cross-examination went terribly. Daniels admitted that she hates Donald Trump and that she wants him in jail. That means that you, as a juror or a prosecutor, can't take her that seriously and can't rely on her for important testimony.
Yeah, it's such an important part of all of this. And, even going back to the idea, is it standard practice? Is when Michael Cohen has these tapes that he's releasing right now to the world about conversations that he's had with Donald Trump when Donald Trump was his client, when they were working together and not, I guess, mortal enemies. Are those tapes customary for an attorney to have, and Cohen just decided to release them, or was he laying a bit of security for himself, I guess, from day one?
It is very unusual. In my law practice, I never ever used an audio recorder to record a conversation with a client. I didn't have too many direct conversations one-on-one with clients, but I also never saw any of my superiors do it. Um, and I mean, you would take notes, but you would, at the top of any notes you would take, you would say, confidential, privileged attorney-client communications, so that people would know, like, oh, this needs to stay in house, it needs to not be disclosed. And you take that really seriously. Like, that, part also of your job as a lawyer is how you handle confidences and how you handle those communications. Like, they should be at the office. Privileged communications should be in a secure folder on your computer or in a secure location. Like, they shouldn't just be spread out all over your desk generally. Like, that's something that the ethics bodies tell you should be doing. I mean, it's a serious thing, because it's malpractice if you waive privilege as a lawyer and then the guy is hurt by those communications. You could get sued for it. You can get disciplined, as Cohen ultimately was.